Hello everyone, I'm your host Nazarat Fatima. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all the courts across the country. Let's begin. We have previously been reporting about the initiatives being made by CJI DY Chandrachud for reforming the court functioning and administration using advanced technology. Today, in another such update on e-court's mission of the Supreme Court, the CJI announced that the Supreme Court is now officially on board with the National Judicial Data Grid, that is NJDG. The NJDG portal is a national repository of data relating to cases instituted, pending and disposed of by the courts across the length and breadth of the country. Developed by the National Informatics Center in collaboration with the in-house IT team of the Supreme Court, the NJDG gives real-time data regarding the pendency of cases in district courts and high courts across the country. This information is categorized by case, type, year, stage and forum. The CJI today displayed the web page for the courtroom, thus highlighting the graphs that could show number of cases instituted and disposed of in the current year and quorum-wise pendency of cases. It also showed impact of vacation periods on case disposals. This is indeed a step forward in the court's open data policy to bring transparency and accountability in the judicial domain. The Prime Minister of India, Mr. Narendra Modi, took to Twitter and lauded the Supreme Court and the CJI for the initiative, stating that the harnessing of technology would further transparency. In another update, the Supreme Court today refused to interfere with the Lakshadweep administration's decision to exclude chicken, beef and other meat from the menu of midday meal for school children, and its order directing closure of all dairy farms run by the Animal Husbandry Department. The background here is that in 2021, chicken and other meat was banned from the midday meals of school children by the newly formed administration of the Lakshadweep Union Territory. Not only this, in the same year, the administration also directed immediate closure of all the dairy farms run by the Department of Animal Husbandry. This move was resisted by a local lawyer, Ajmal Ahmed, who approached the Kerala High Court in a writ petition. The petition was dismissed by the High Court, and now the litigant approached the Supreme Court in an SLP. Last year, the Supreme Court, while agreeing to take the appeal on board, had issued a stay on the operation of orders under challenge. Today, the bench of Justices Anuruddha Bose and Bella M. Trivedi was hearing the matter and declined to interfere on the grounds of the limited scope of judicial review in matters within the realm of executive policy. The bench stated that as far as the midday meal was concerned, the administration had retained non-vegetarian items like egg and fish, which were available in abundance at the said islands. What was being questioned in the appeal was primarily a policy decision of the administration, and no breach of any legal provision had been pointed out. The court had to accept the administrative decision in this regard unless some outstanding arbitrariness was pointed out. After orally dictating the order in the court, Justice Bose also said, and I quote, "We cannot import personal preferences in policy matters." Superstition and witchcraft have a long history in India, deeply rooted in our diverse cultural and religious traditions. While efforts have been made to combat witch hunting through legislation and awareness campaigns, these traditions continue to play a significant role in many parts of the country, with serious social and gender-related consequences. In one such case, the Supreme Court has upheld the rigorous life imprisonment sentence of convicts in a witchcraft-related murder case, observing that they had a common intention to kill the victim. The case is related to an incident where the 5 accused persons called the deceased a witch and a cause of trouble to the villagers as she used to indulge in witchcraft. They surrounded her and her daughter-in-law while they were returning home after their daily routine. The victim was brutally assaulted, causing her to fall and die instantly. A case was registered and the accused were convicted and sentenced to rigorous imprisonment for life by the trial court. The High Court affirmed this judgment in 2010. Against this, they appealed before the Supreme Court. The Supreme Court bench, comprising Justices Abhay S. Oak and Justice Pankaj Mittal, upheld the High Court decision. The court observed that the accused had assembled in the morning and surrounded the deceased with deadly weapons. This was a sufficient indication to infer that they had gathered in a pre-planned manner with a predetermined mind, thus clearly showing their common intention. The court also noted as the appellants had served a sentence of 15 years in jail, they could seek remission in accordance with the prevailing policy of the state. In another significant development, senior advocate Vijay Hansaria, who is the amicus curiae appointed by the Supreme Court in the matter relating to criminal cases against elected representatives, in his 19th report has suggested permanent disqualification of convicts instead of a 6-year ban. He has suggested that limiting the period of disqualification to contest elections after conviction to 6 years is manifestly arbitrary and violative of Article 14 of the Constitution. As you know, presently, when an MLA or MP is convicted for any offence, by virtue of Section 8 of Representation of People's Act, they are disqualified from contesting elections for a period of 6 years since the release. The constitutional validity of this provision is under challenge by the present writ petition filed by Ashwini Kumar Upadhyay. Let me tell you that the matter is to be heard by a bench led by CJI D.Y. Chandrachud tomorrow. The amicus has stated in his latest report that statutory authorities under various legislations including the Central Vigilance Commission Act 2003 and Lokpal and Lokayuktas Act 2013 provide for permanent disqualification and removal from holding statutory office if an officer has been convicted of an offence involving moral turpitude. The amicus has contended that as long as statutory authorities do not allow convicted persons to occupy office, it is manifestly arbitrary that convicted persons can occupy supreme legislative bodies after expiry of a certain period of conviction. In this case, a divorced daughter challenged a family court order, rejecting her claim of maintenance from her mother and brother. Her father had died in the year 1999, leaving behind his wife, son, and 2 daughters. The woman told the court that she was not given any share. She contended that her mother and brother agreed to pay Rs 45,000 per month to her as maintenance on an assurance that she would not press for her share in the property, and then she stated that she was given maintenance regularly only till November 2014 and not thereafter. The Delhi High Court in this case has observed that a divorced daughter is not dependent under the Hindu Adoptions and Maintenance Act 1956 and that she is not entitled to claim maintenance from the estate of her deceased father. The court also observed that no matter how difficult the situation may be under the HAMA, she is not dependent as defined under the Act and thus not entitled to claim maintenance from her mother and brother. The persons accused in the 2020 Delhi riots larger conspiracy case have moved a Delhi court seeking clarity from the Delhi police on the overall status and completion of its investigation in the case being probed by the special cell before proceeding with the arguments on charge. The applications have been moved by Devangana Kalita, Natasha Narwal and Asif Iqbal Tanha before Additional Sessions Judge Amitabh Rawat of Karkaduma courts. In their application, Kalita and Narwal have sought a direction on the Delhi police to state on record the status of investigation in the case and also to indicate when the probe will be completed. They have prayed that the probe agency be permitted to proceed to the stage of arguments on charge only after filing of a report before the court. Meanwhile, Tanha has also sought a direction on the Delhi police to indicate a timeline as to when the probe will be completed. He has also prayed the investigating agency to state on record that the investigation regarding him stands completed prior to advancing arguments on charge. To remind the viewers, the accused in the case are Tahir Hussain, Umar Khalid, Khalid Saifi, Ishrat Jahan, Miran Haider, Gulaf Shah Fatima, Shifaur Rahman, Asif Iqbal Tanha, Shadab Ahmad, Tasleem Ahmad, Salim Malik, Mohammad Salim Khan, Athar Khan, Safura Zargar, Sharjeel Imam, Faizan Khan and Natasha Narwal. Today, the Principal Sessions Court Chennai remanded former Vishwa Hindu Parishad leader RBVS Manian to 14-day judicial custody in a case for allegedly making derogatory remarks against Dr. B.R. Ambedkar. Mr. Manian was arrested by Chennai City Police on Thursday morning from his residence in T. Nagar after a video went viral where the former leader was seen making alleged derogatory remarks against Dr. B.R. Ambedkar and Thiruvalluvar. Manian had also allegedly belittled people belonging to the scheduled caste community. The police had registered a case against him under the provisions of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act and the IPC for disturbing public tranquility and creating enmity between two groups. After arrest, he was produced before the District Sessions Judge S. Ali, where he said that his statements were misunderstood and requested the court to consider his health and age. The court then remanded him to judicial custody. When a request was made to allow Manian to be treated at a private hospital, the court remarked that the request will be considered. A sessions court in Gujarat's Ahmedabad today dismissed a revision application filed by Delhi CM Arvind Kejriwal and Aam Aadmi Party Rajya Sabha MP Sanjay Singh, challenging the issuance of summons by a magistrate court in a defamation complaint filed against them. The case has been filed by the Gujarat University over the alleged remarks made by the duo in connection with the academic degree of Prime Minister Mr. Narendra Modi. After hearing the arguments of all the parties, Judge J.M. Brahmbhatt reserved the order in the matter last week. Advocate Om Kotwal for Mr. Kejriwal and Advocate Farooq Khan for Mr. Singh argued that the trial court's summoning order was wrong and that the Gujarat University could not have filed a defamation case in this matter as it is not the aggrieved person. It was also their common ground that the statement in question does not amount to defamation. That would be all for today's episode on Courts Today. If you wish to learn more about these cases, please go to our website, which is www.livelaw.in, and look for the news you're interested in. Keep supporting us by liking and sharing the videos, and of course by subscribing to our YouTube channel. Thank you for watching.